I'm extremely mindful of the time, that I have 4 minutes. And the last speaker, I'm also aware that being the last speaker before a lunch break is also not good for me or good for you. I will attempt to cut down then where I can, and clearly no questions. Before I speak, I acknowledge that I am in the lands of the Wurundjeri Wurrunga people of the Kulin Nation. I wanted to tell you a little bit about a project that I've been asked to be involved with. In fact, I was at a conference earlier this week where I spoke or participated, and it's an invitation of CVAW, which is the Australian Research Council's Centre of Excellence for the Elimination of Violence Against Women, CVAW. It's the world's first centre to address full-range forms of violence against women in Australia and in the Indo-Pacific region. Their literature speaks about pioneering new evidence-based approaches to inform trajectory-altering practice and policy. They also say this interdisciplinary research will be data-driven, Indigenous-centred and co-designed with partners. I've been asked, I'm a member of the Australian Association of Women Judges, who've been asked to partner with CVAW a project. The project, this is the working research question, which is, what is the best practice for judicial officers to ensure protection order proceedings are safe and culturally responsive for Aboriginal and Torres Strait Islander women who are victim survivors of family violence? First, how are judicial officers ensuring Aboriginal and Torres Strait Islander women, for convenience, I'll just say Aboriginal because I'm just trying to shorten it, but just know that when I do speak about, let's say, Aboriginal or Torres Strait Islander women or people, they're very different people with different cultures and different histories. And so even though there's often the grouping together of the words, please know that I don't fully understand, but I do respect the significant differences in cultures. The second is, are current practices of judicial officers reinforcing women's experiences of harm in protection order proceedings? If yes, what are these practices? And what role do Aboriginal and Torres Strait Islander court support officers play in supporting Aboriginal and Torres Strait Islander women who are victim survivors of family violence? I'm not a researcher, I'm not involved in the research, but myself and Justice Louise Taylor have been asked to be part of the partnership with CVAW. In relation then to what the research is, I'll read to you, I won't be reading a lot from the documents, although I will be taking from the literature review, which is excellent, which has been prepared by CVAW. Firstly, the introduction says, and I'll just say women's experience, so I'm referring to Aboriginal and Torres Strait Islander women. Women's experience of the judicial system is shaped by intersecting factors. Women's experience high rates of family violence alongside structural forms of violence and racial inequality through incarceration and the criminal legal system. This intersection influences how women experience mainstream legal systems, including the judicial system. Although sentencing courts exist, their scope is limited. The vast majority of legal matters involving peoples are heard in mainstream courts. And as Caneen says, that women's engagement with legal and social support services say it is likely that there are further compounding factors for Aboriginal and Torres Strait Islanders engaging in the judicial system, such as cultural approaches and understandings of justice. However, the gap in literature is another area. Finally, in the introduction it says, in the review, we centre Aboriginal and Torres Strait Islander voices and consolidate literature that provides insight into both the potential avenues and barriers towards a culturally responsive and respectful family violence protection order system. They conclude by saying, "We also highlight that this research is only one part of a broader picture and call for consideration to be given structural change and responses that sit outside of settler legal systems." Before I come back to the research, I wanted to speak a little bit about myself as a judicial officer, and I'm going to give you really a disjointed snapshot of some experiences or matters that I've observed. I've been a magistrate for 25 years. I am the second most senior magistrate in Queensland and the most senior full-time magistrate in Queensland. In January 2020, 3 months before COVID hit, I moved to Cairns, where I worked for 3 years. It is really there some of the experiences that I want to tell you about. In Cairns, the magistrate circuit to remote communities in the north. We sit in Pomperour, Arakoon, Bamaga, Thursday Island, Mur and Saibai, to name just a few. These places are either communities or towns at times, predominantly Aboriginal or predominantly Torres Strait Islander, although places such as Bamaga, there are Aboriginal and Torres Strait Islander people. So this is just a snapshot, and again mindful of time, of some of my experiences. As I said, I've been a magistrate for 25 years. Before that, and was about 23 years in Cairns. Before that, my first job, I did articles of clerkship in the olden days. My first job as an employed solicitor was at the Aboriginal and Torres Strait Islander Legal Service in Brisbane. And before I was appointed, I had my own law firm. So I've got a lot of experience in working, especially in criminal defence work. For those of you who work, and it's been spoken about here, the Magistrates Court, really at the coalface of huge, enormous workloads and so many factors. The courts that you would know is probably, we call it in Queensland, usually if there's more than one courtroom, Court 1. And Court 1 in Cairns is your first court that you would come to, and it's also, if people are in custody in Cairns, they also appear in that court. It's the main court where most matters begin. I can remember the very first day when I was in Cairns, that I sat in the way, it's a courthouse in a large sort of country area, and what there's a dock, as most courtrooms have, a glassed-in dock. And the first time that I saw that I went into court, the dock was full. And many of these things moved me, I'm sorry, so this is what intergenerational trauma does look like for our speakers. But the first time that I went into that courtroom, every person in that dock was black. I'll then change, that's one story. These are going to be disjointed stories. The other thing is that we do, as I say, we are a fly-in, fly-out justice system in the communities. We usually fly to a town in the north, such as Weipa, or in the Torres, the Thursday Island. When we're in that's where we're based, we'll sit in those towns, but we then fly in and fly out to the remote communities, flying out in the morning, sitting for the day, flying back in the evening, staying at the centre, and then flying out the following day. The other matter when I went to work in North Queensland, despite my some 40 years experience in the criminal justice system, is that nothing prepared me for the level of violence in the north. That's the level of violence, even in places such as Cairns and those in the remote communities. I was truly shocked at the seriousness of the violence and the significant injuries that people received. The other is the volume of work, and I'll speak now in relation to, I can say now as a magistrate in 25 years, I have never, ever worked harder. The workload is enormous, but I'm back in an urban setting. I'm back in Brisbane, where I have been now for the last 2 years. But the volume of work in this circuit work, I telephoned my clerk, who was my clerk when I was in Cairns, to get some of the numbers from the reports that she had. And we were discussing, and she said to me, which we all know, it is actually impossible to deal with all the matters that are listed on circuit. You cannot possibly deal with everything. We also deal on circuit with numerous other contingencies. There have been times where there's been no internet or any access. You can't even use a mobile phone. You can't ring the prisons to say we're not getting people on the video for sentencing because we can't contact the prison. Total blackout, can't contact anybody. Other times, maybe it's not the internet, but scanners don't work, printers don't work. The contingencies of just the reality of running a court is particularly onerous for the staff. When I go to places such as Arakoon, where the population is about 1,100 to 1,200 people, mostly traditional owners, but about 10% would be non-Indigenous, because there's a lot of government services and police, teachers in these towns. And then if you go into the town where I've had reason to go in, it can be on one street, and on the left-hand side it's gated, sprinklers, gardeners, and on the other side, third world. So in a town of Arakoon, where there's about between 1,100 and 1,200 people, when looking at the statistics of what we did, the average number of domestic violence matters each month would be 20 to 30. So in a town of about 500 adults, there are multiple orders against people, and such that a huge percentage of the adult population would be subject to some form of domestic violence order. In relation to these domestic violence orders, usually neither the aggrieved nor the respondent come to court. And because of the level of violence, and many of the police, including young and experienced police, often seek orders of no contact. I have to decide domestic violence orders that in a small community where there are kinship and family relationships, and a community whose history and circumstances I don't understand, I'm expected to make orders that might include, and I'll use some of the language that's used in Queensland, but I'm sure you understand, ouster orders, which means someone is removed from the home, or no contact orders between people. We do in Queensland have community justice groups. It's legislated, they're in the communities. When I go into remote communities, I attempt to form relationships with the community justice groups, and I would often ask them, or the people that worked with them, if they might drive into the town and ask the people who are the subject to these orders if they would come to court, and if they would tell me how these orders might work, or even if they want an order. But invariably, I make orders without input from the persons who are directly affected, and these orders have significant consequences. One of the consequences is the high rate of imprisonment of Aboriginal men and women who breach these orders. I can remember when I was one time in Arakoon, one of the elders, Auntie Pearl, came to court in a particularly dilapidated wheelchair. She'd come to court and she asked me if I would remove from a domestic violence order against her daughter, that meant she could have no contact with her daughter because she could not care for herself, and her daughter was her carer. Also, when we fly into these communities, I fly with the legal service and court staff, and the police have a separate aeroplane. And the amount of work, even if having an experienced lawyer, the lawyers tell it is simply not possible to see every person, to take instructions. And these can be really very, very serious matters. They have about 2 to 3 minutes, they say, per person. Also, when we are in community, neither I nor they understand the community itself and the factors that influence that community. I can remember in 2022 when I was there, as I said, I wanted to form relationships with the community justice groups, and also at the time there were mediators working in the town. The mediators came, and the mediators, I would meet with them as well as a community justice group. One of the things that can happen in the town is, whatever I say, please know I don't do it justice. I don't have any historical or proper context, and really this is just anecdotal from my experiences. There is in the town of Arakoon, there is significant feuding between families. This feuding can take the form in the streets where people might arm themselves with various items, concrete, weapons, machetes, rocks, pieces of wood. Some of that is, though, more jousting, and again, I don't know the complex history of these types of this can happen in communities, but it's a kind of a jousting where the groups come together and go apart and disband. There can arise out of these a number of arrests for what in Queensland are called public nuisance offences or affray offences, where people are involved in this public dispute. In January, and again, I'll do this as anecdotal, I haven't documented any of this, and some of what I tell you is from my very best recollection of some years ago. In January 2020, there was a feud between the groups, and one young person was speared and died. The feuding escalated such that many people fled into the bush, and I know that when I first lived in Cairns in January 2020, there were many displaced Aboriginal people from Arakoon, which is a hard fit for them. They're dark-skinned people whose English is not their first language. Cairns, a tourist destination, and the misfit of all of that I observed as a newcomer to Cairns. What had happened with when I met with the mediators that day, they told me of a story, and the community justice group was there, so I was able to confirm with them some information that when this young man was killed, he had a young partner. I believe he was in his early 20s, and his young partner was as well. So when he died, for her to repartner, there are certain practices in the community, well, let's call it community, but there are certain practices in Arakoon, which I'm told was included. She had to be charcoal washed by his family, and also the brothers had to do a house opening of the deceased's house. What happened, however, is that the two of the brothers who were required to do the house opening, when this feud had escalated, they burnt down some of the houses of the person who had thrown the spear. They were charged with arson, and they received periods of imprisonment of about 5 years. So this charcoal wash and house opening, in the usual course, would happen in a timely way. But with the brothers in prison, it was now some 2 years and it hadn't occurred. The young girl who had partnered the deceased, I don't know, I don't have the full story, but she'd either repartnered or she was speaking to another boy or something like that. I'm told that she was assaulted by 3 women in this man's, the deceased family, as a consequence of her breaking these rules. I know that story because I've sat with the mediators in the community justice group, Know also that when it comes to, my clerk also tells me that she's worked with magistrates who fly into communities, community justice groups come into court, will sit there in court the whole day and the magistrate won't even speak to them or acknowledge their presence. So I met with the community justice group and the mediators. I then went into court, knowing of course that the lawyers, there's a whole lot of reasons, but one is time. There's simply not time. I then have a matter before, and I had the mediators in court because sometimes they're involved in the mediation regarding all the feuding. The mediators were in court. The legal service comes in with a woman. She has no criminal history, which in itself is remarkable to live in Arakoon. She has no criminal history, and I say that as a context of circumstances. But she has no criminal history and she works. She's a full-time worker and well regarded in the community. So the prosecutor reads the facts of 3 women assaulting 1 woman, and they gave her a bit of a flogging. And then the duty lawyer, the legal service says she's got no criminal history and she works. That's what I get in court submissions. That's what I'm expected to deal with. But I had spoken that day earlier to the mediators and community justice group who were in court, so I was able to put all of that on the record. But imagine how often I deal in circumstances where I have no idea what's really going on. And if I had not had that information, and when I sentenced that woman, if she had been thinking to herself she doesn't know what she's talking about, she would have been right. Then the other matter I wanted, I'm also, sorry, I'm mindful of the time. It's 1 o'clock. I will tell you then, I'll go through these notes. I'll tell you just one more story and then I've realised how late it is, I'm sorry. When I was working in Cairns, I also ran the mental health list. The mental health list is a complicated list. Most people don't have much idea of what they're doing. I had an Aboriginal woman, I had a file before me, that of an Aboriginal woman. She was, the lawyer came in and said they wanted a 6-month adjournment because they didn't have the mental health report. I said, is your client in custody? I knew because it had a blue sticker on the front. Is your client in custody? The lawyer didn't know. How long has your client been in custody? The lawyer didn't know. I said, I'll have a look. Your client's been in custody for 18 months. I am not giving you a 6-month adjournment to get a report. And in fact, on normal sentencing theory, if someone's been in custody for 18 months, you might think that's a head sentence of 4.5 years. In Queensland, if you get parole at 1/3. And so I said, do you say this is so serious, this matter can't be dealt with in the magistrate's court? The lawyer didn't know, had no information. I said, well, I want to consider a bail application for this matter. And then the following day, the police came. The facts were that, the police came the next day. They did not oppose her bail. She was on the video screen. She was profoundly disabled. She was non-verbal. She could not speak. The prison psychologist was there and said, please do not release her into the community. She cannot survive. She couldn't negotiate even the most basic of things. And so I'd said to the lawyers, contact sisters inside. They did, and she was transported home. Her offence was that she was attempting to cut her mother's hair, but with her profound disability, she was hurting her mother. So there's domestic violence applications brought. She's been in custody for 18 months. And anyone would say that she will be found unfit. She could never be fit for trial. So I'll finish my stories there. The other thing I did write was jealousing, and I wrote, what the hell is that? So if any of you have ever, I think in the city we call it coercive control, but it's a serious, serious issue. So in conclusion then, coming back to the research, I can say that in the criminal law, classic sentencing theory does not apply when dealing with much of the work that you do in the environments in which I spoke. I'm not dealing with the man on the Clapham omnibus or the man on the Bondi tram when I'm dealing with it. It takes me back to the earlier when his judge was speaking about bugmeat. But then how Then, what is the best practices for judicial officers when we're dealing with Aboriginal and Torres Strait Islander women? And the research question. I'll come only then to the conclusion, and I gave you those examples for you to know that as a judicial officer, some of the things that we deal with when we're working in a system which is distorted and opaque. But the conclusion is of the CVOR literature. In this review, we have examined literature that considers Aboriginal and Torres Strait Islander women's experience of family violence protection order proceedings. We have argued that there are limitations in terms of our current knowledge as to judicial officers and best practice. These limitations relate to gaps in our understanding about the three key themes that we have explored in this review. First, how judicial officers and courts can challenge structural barriers to Aboriginal and Torres Strait Islander women's participation in court proceedings. Second, how judicial officers can work to prevent and limit Aboriginal and Torres Strait Islander women's harmful experiences related to family violence and protection order proceedings. Third, then there's the understanding, which is actually vital, of the roles of Aboriginal and Torres Strait Islander court support officers. They say, furthermore, returning to the quote from Langton that we raised at the start of this review, these limitations in our current understandings also raise broader questions about what justice and cultural responsiveness looks like in the judicial system for Aboriginal and Torres Strait Islander women who are victim survivors of family violence, and importantly, whether mainstream courts can operate as a mechanism of justice at all. Thank you.